Good day, sir. I'm Ibian S. Bumanlag from 4G1 BS Criminology. I'm going to discuss what I've learned in this subject, criminal procedure and court testimony, for my midterm examination. So we start to tackle Rule 114, which is bail, to Rule 118, pre-trial. Let's define first the Rule 114, which is bail. Bail is the security given for the release of a person in custody of the law, punished by him of or advancement. For my own understanding, it means that the accused is innocent until it's proven guilty. When the accused is not proving his guilt or responsibility, he is an innocent citizen on the eyes of the law. No, this privilege is given with defending case or to those detainee because they have not yet a final judgment, and um, it's applicable only to one who is under the custody of law, not to the one who is at large. This system assured that there is no person take his or her liberty because of wrong accusation. Judgment cannot grant bail motu proprio. The judge cannot by himself grant bail because a hearing should be held first when grant of bail is discretionary. Also, even though the court allow you to grant bail, doesn't mean you are allowed to travel. Your right to travel is prohibited from leaving the country. Under the rule of 114, there is a forms of bail, and those are the property bond, cash bond, recognizance, and the corporate security. The first bond is the property bond, an undertaking constituted as lien on the real property given as a security for the amount of the bail. Meaning to say, the defendant provides the court with the property as a form of bail. Next is a cash bail bond. Cash bond is forfeited to the court if the defendant fails to appear in the court, even its accidental forfeiture, or however, the person who posts a cash bill can receive a refund after paying it, but the court will keep a portion of the money for administrative fee and may take several months to issue the refund. Lastly, the recognizance. Recognizance is the most often encountered regarding in bail criminal cases, and there is a restrictions within the recognizance. It allowed only when the offense is like felony, violence of ordinance. The ordinance offense is not punishable by more than 6 years imprisonment or the amount of 20,000 pesos. Also, if the accused applied for probation, he is not capable of paying bail. Under the RA 6036, to provides that no bail is required if offense is violation only of city or municipal ordinances, including of violating local speed limits and polluting public water supplies, etc. The penalty is not higher than arresto mayor. The duration of the penalty of arresto mayor is uh, shall be from 1 month and 1 day to 6 months with fine of 20,000. Next is the summary hearing. The summary hearing for applications for bail shall be in summary in nature. From the word itself, summary, giving a brief or expedite receiving the evidence of guilt. Yung pangmabilisan. Take note, no? Remember Section 13, Article 3 sa Constitution. Excessive bail shall not be allowed. Excessive or yung sobra. You should pay according to the crime you committed. You are able to pay your bill into the nearest collector of PIR or the provincial, city, or municipal treasurer. Next is let's determine that the bill is when the bill is forfeited or cancelled. You can tell if the bail is forfeited if the accused fails to appear in person as required by the court, while if the bail is cancelled, the case is dismissed, surrender of the accused or acquittal of the accused, and proof of his death. So we also need to supervise detainees, no, under the Rule 114, Section 25, na the court supervision of detainees, no. There are detainees, yun yung mga undergoing yung case pa lang. The court has jurisdiction over persons in custody for the purpose of eliminating unnecessary detention. Next is the executive judge of regional trial court or RTC shall conduct monthly inspection of jails to a certain number of detainees. It's very important on conducting inspection of the executive judges to examine the condition of the jail facility for ordering the segregation of sexes like minors from adult. Yan. Strive to eliminate conditions inimical to detainees and to ensure the observance of the right of the detainees to confer privately with counsel. Dito papasok na yung the Rule 115 or the rights of the accused, no? The right of the accused is to be presumed innocent until the contrary is proved beyond reasonable doubt. Like what I've said earlier, define bail is he or she considered as guilty until it is proven, and it in the eyes of the law he is innocent beyond reasonable doubt. So we have called equipoise rule. Based on my own understanding, this rule was 50-50, meaning to say the court has a presumption if the accused is innocent or guilty. The court was favored on the accused and is acquitted because of lack of evidence. Next is the right of the informed of the nature and the cause of accusation against him. Third is the what you call that, the right to be present from arraignment up to promulgation of judgment. In this arraignment, it is the first step in criminal proceeding where the defendant is brought in front of the court to hear the charges and enter a plea to promulgation of judgment, meaning to say public declaration with ito na may final judgment. Eto na, next is the right to testify as a witness in his own behalf, no, madi-discuss naman dito. And we discussing here the American rule and the English rule. American rules, this the witness can only be cross examination on matters covered on direct examination, no, saklaw. English rule. Ordinary witness may be cross-examined not only on the matters directly inquired on direct examination, but also on the other matters connected connected but related dun sa case, unlike sa American rule that there is a covered or scope to examine. No, according naman sa RA 8493, the Speedy Trial Act of 1998, from the word itself speedy, para mabilis ang procedure of trial and ma-free sila sa vexations, compression, or pagbabago and oppressive. And now let's proceed to Rule 116, which is the arraignment. Arraignment define the proceeding in criminal case whose object is to fix the identity of the accused, to inform him, especially to inform of the charge against him, and to give him an opportunity to plead. On my own understanding, arraignment is to inform the defendant of the criminal charges against him or her were able to ready and aware him in court. Like what I've said earlier, arraignment is the first in the criminal proceeding rather up to promulgation of judgment. And the validation of arraignment The accused must be arraigned within 30 days from the time court acquires jurisdiction. before before the court where the complaint or information was filed or assigned for trial, and also by pangunguna ng judge or clerk by the furnishing the accused with a copy of the complaint or information, the language or dialect he is known, dapat alam niya at naiintindihan niya, no? Improvement plea of guilt. No, a plea of guilt is imprudent if it was made without proper advice or recklessly entered by the accused without comprehending its seriousness and consequences, no? Because of sometimes because of their emotion nakakapag-akusa ka from that, pero from that you can withdraw or imprudent plea of guilt anytime before the judgment of conviction becomes final, no? The court may permit an imprudent plea of guilty to be withdrawn and be substituted by a plea of a not guilty, no? According naman sa Rule 117 or the motion to quash, it defines a motion to quash. It's substantially the equivalent of motion to dismiss and civil cases provided in Rule Section 8, Rule 16 Section 1 rather, sorry. It is a formal motion filed by the accused before the arraignment. You can file the motion to squash or anytime before entering his plea. No, the court only whom grant the motion to squash, only the court may order that another complaint or information be filed. However, there is an exemption. The exemption when the ground is extinction of criminal liability or double jeopardy. So what is double jeopardy? It defines the rule means when a person is charged with an offense and the case is terminated either by acquittal or conviction or any manner without the consent of the accused, the latter cannot again be charged with the same or identical offenses. It's embodied in the maxim non bis in idem, which translates literally from Latin word as not twice in the same, meaning no person shall be punished in the same offense. Let's now determine the difference between acquittal and dismissal. No, acquittal, it is take place when there has been a fully blown trial, um, and it's not found guilty for whatever reason, while the dismissal takes place now when there has a no full blown trial and the case was not decided on the merits. The last topic that I will discuss the last topic that I'll discuss was the Rule 118, the pre-trial. Pre-trial is a mandatory or recognizable by the Sandigan Bayan, Regional Trial Court or the RTC, Metropolitan Trial Court or the METTC, Municipal Trial Court in cities, Municipal Trial Court and Municipal Circuit Trial Court or the MCTC. The court shall arraignment and within 30 days from the date from the date the court acquires jurisdiction over the person of the accused, order a pre-trial conference. So, what is pre-trial agreement? First, all agreement or admissions made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel, otherwise they cannot be used against the accused. Next is the pre-trial order. After pre-trial conference, the court shall issue an order reciting the actions, the taken, the facts stipulated, and evidence. Right? That's all. Thank you.